Hello there, my dear friends. We shall continue with the balance of the bar examination question on April 4 in the morning on the law of the state. And the political law component has already been uploaded. And this is now the balance of the 18 questions. There are three questions in labor law and three questions in taxation, and they're very reasonably fair. For those who study as regular students can answer them. Those who were cramming probably will have a little confusion, but overall, I think Justice Loanen was very fair to you when he gave you the six questions, three for labor law and three for taxation. So without much ado, this is Dean Joe-Santos Balagtas Bisquera continuing with the lecture suggested answers to the bar questions. I will skip this particular slide because most of you have been following my slides already know me, coming from the fields of the academe, corporate management, and the field of law. By way of simply highlighting, I am the Dean of the College of Law of the University of Manila, its Vice President for Legal Affairs, and a member of the Board of Trustees. I am a practicing lawyer, and this is my second stint to be the Dean of the College of Law. I was also the Dean of the College of Law from the year 2004 to 2009. In 2006, we garnered one of the most impressive 75% passing for our first takers. In fact, we were hoping two of our candidates would have landed in the top 10. So without much ado, let us now continue with our get-together. On this particular slide, we would see the coverage, the two remaining subject matters on labor law and on taxation. In the field of labor law, what was given was essentially a question on self-organization. The next question is it already moved anyway. We'll just continue. And this is the question on self-organization. A non-governmental organization operating in the Philippines which seeks to promote equality and human dignity in the workplace has 40 rank and file employees. This is question number 13 in that bar exams. Can the employees of this cost-oriented non-governmental organization form a labor union? Explain. Our suggested answer, yes, the employees of a cost-oriented non-governmental organization can form a labor union. The state guarantees the rights of all workers to self-organization, collective bargaining and negotiations, and peaceful concerted activities provided they are not employees of religious, charitable, medical, and educational institutions not operating for profit. This was the Supreme Court pronouncement in the case of Arizala versus People. The second case on labor is problem number 14, and it has something to do with illegal dismissal. The problem reads, upon the owner's instructions, the restaurant manager served a notice of termination on a cashier who has been employed in that restaurant for more than 5 years. Effective immediately, the notice was based on the alleged insubordination of the cashier. The owner had ordered the termination immediately after learning from the manager that the cashier was asking whether the restaurant was remitting Social Security system contributions deducted from employees' salaries. Will an action for illegal dismissal filed by the cashier prosper? Explain briefly. Our explanation. Yes, the cashier can file an action for illegal dismissal. The cashier did not commit any insubordination when she asked whether the employer was remitting their SSS contribution. The employer issued no order for which the cashier did not comply. The employer failed to observe substantive and procedural due process of law in determination. The employer also failed to observe the required two-notice rule on procedural due process. Those are very basic questions in labor law. The next question on labor law has something to do with probation. This is number 15 in that bar examination question. Here the question reads, in 2019, as a response to a viral Pound University Do Better movement, a university announced that it would create the position of independent gender auditor answerable only to the university's Board of Regents. The Pound University Do Better movement had arisen when a high school student started to post on social media complaints alleging sexual improprieties by some professors. Others soon followed with their own stories. Even traditional media outlets covered their stories. True to its promise, the university engaged one of its former professors with profound feminist views as gender auditor. The contract stipulated a performance review after 5 months of gender auditors being engaged. The gender auditor's performance was never the subject of any assessment by the Board of Regents. For about 2 years, the gender auditor submitted several candid findings on the behavior of some members of the university's faculty and administration. In January 2021, the gender auditor submitted a report that the university's management, including the Board of Regents, enabled and facilitated a hostile environment not only for women but also for those sexual orientation, gender identity, or gender expression were considered non-conforming. That is, members of the lesbian, gay, bisexual, transgender, queer, intersex, asexual, and other gender and sexual minorities community. This report leaked and stirred a controversy, causing the university president to be dismissed from their post. In January 2022, after the president's dismissal, the gender auditor received a letter from the Board of Regents requiring the submission of a performance assessment to determine whether the gender auditor can be considered a regular employee. In January 2022, after the president's dismissal, the gender auditor received a letter from the Board of Regents requiring the submission of a performance assessment to determine whether the gender auditor can be considered a regular employee. It looks like that portion should have been deleted. The gender auditor seeks our advice because you passed the Pound Best Bar Ever 2020-21 and were recognized for exemplary performance. Is the gender auditor still a probationary employee? Explain. Our suggested answer, the gender auditor is a regular employee. When the auditor worked after 6 months probationary period, he is considered a regular employee after said probation. There was no standard to qualify him to be a regular employee. In that particular case, he is deemed a regular employee when hired with no standard with not standards when no standards were known to him at the time of hiring. That is a very important component, that when you hire an employee, when an employee is hired, that employee becomes a regular employee even when he was told that there will be a probationary period, when no standard of performance was given to him to allow him to meet such standards. That means, conceptually, the employer has waived the prerogative to put him on probation with the absence of the standards of performance. Okay. Now, let us now move to the subject matter of taxation, and there are essentially three questions on taxation. The first question on taxation is something to do with the value-added tax. The second question has something to do with the donor's tax. And the third question deals with the issue of tax assessment and the prescriptive period for such an assessment. On the question of value-added tax or VAT, problem number 16 in the bar examination reads, the receipt of your purchase of a mobile phone charger shows that you just bought it for 2,100 pesos. Sorry. The receipt shows that the total amount is broken down between the selling price of the charger, which is 2,050 pesos, and the value-added tax, which is 50 pesos. Is the amount of value-added tax correct? That is the 50 pesos. Explain briefly. No, the value-added tax is not correct. When the VAT exclusive sales receipt is 2,050, the 12% VAT is correctly at 246 pesos. So the 50 peso VAT here is not correct. The second problem has something to do with the donor's tax. Problem number 17 in that bar examination. After finally passing the bar examinations, a new lawyer was given an engagement ring worth 1 million by a long-time significant other who happened to be one of the most junior sitting justices of the Supreme Court. Their relationship has so far been platonic. Being an avid supporter of the current government, the new lawyer told the significant other that the gift would only be accepted if all taxes due had been paid. Is there any tax liability arising from the giving of the engagement ring? Explain briefly. Our suggested answer is yes. The donor's tax liability is 6% in excess of 250,000, amounting to 750,000 times 6%, and the correct donor's tax is 45,000. The third and final question, number 18, in that bar examination has something to do with tax assessment. The problem reads, a corporation received a letter of authority from the Bureau of Internal Revenue for 2015, which is also the corporation's taxable year. By the end of 2019, the Bureau of Internal Revenue had yet to complete examining the corporation's books. In January 2020, before the onset of the COVID-19 pandemic, the Bureau of Internal Revenue issued a final assessment for deficiency taxes for 2015 based on the same letter of authority. The Bureau of Internal Revenue only found a deficiency in the income tax but did not find fraud. Is the assessment valid? Explain briefly. Our suggested answer: no, the assessment is not valid. The 3-year corporate 2015 tax assessment prescribed on April 16, 2019, after the final adjustment return was filed on April 15, 2016. The January 2020 BIR assessment is a prescribed one. Now, there are certain very important fundamentals in tax administration that has to be borne in mind by the evolving new lawyer from this 2022 bar examination. Here, there can be confusion, and I would not be surprised if some of the candidates did not look at this closer. Now, take note that the taxable year that is being assessed is 2015. If this were a calendar year that starts from January, it ends on December 31, 2015. Now, the income tax, the final income tax return, because there are 3 quarter taxes paid in the interim on a 60-day after the close of the quarter cumulative, will not be followed in the 4th quarter, because the 4th quarter will be the total year income tax minus what was already paid on installment on the first 3 quarters. And so the total year consisting of the 4 quarters minus the payment of the 3 quarters is due for payment not on the 60th day at the end of the 4th quarter, but on the regular timetable of April 15 of 2016, the following year. Now take note, the counting of the 3-year prescriptive period does not start on December 2015. It starts at the time of the filing of the tax return due on April 15, 2016. So if you count 3 years, 2016 to 2017 is 1 year, 2017 to 2018 is 2 years, and 2018 to 2019 is 3 years. So on April 15, 2019, the BIR's tax assessment would have already prescribed. And so therefore, on January 20, that January 20 assessment has prescribed earlier on April 15, 2019. Okay, now, the mistake of the candidates in the bar would be in the rush to submit an answer. They will start counting 2015, 16, 17, 18. So they will say that the prescriptive period of 3 years has already set in on April 15, 2018. That is not correct, because the counting will start on the deadline of the income tax return, which is not 2015 but on April of the following year, 2016. So that is the only thing that is critical. This, my dear friends, would end up our discussion of the second part of the law of the state, which consisted of 3 subjects: the original political law, labor law in this case, and taxation. There were 18 problems, 3 from labor and 3 from taxation, which means 18 minus 6 is 12. There were 12 problems that were taken up in the coverage of political law, and that is covered by recently uploaded suggested answers also on political law. So this second upload becomes in effect the the winding up of the uh, February 4 examination in the morning up to lunchtime. And please await for some more. I have already earlier uploaded, I think 3 weeks ago, the suggested answers to uh, personal and business relations. No? But my QuickTime microphone did not work well at that time. So many have sent me saying, Dean, we have gone through your answer, but we would still welcome your commentary. And so in a little while, I will be uploading my commentary and withdraw the talk less upload of the suggested answers on the what do you call this, on the second Sunday, actually the February 6 morning examination, which will be consisting of two major aspects. Actually, three. You know, the personal and the other one also on personal relations. So that will be uploaded. So wait for them. And right now, I'm already finalizing my suggested answers also to procedural law, which covers both remedial law and legal ethics. Maraming pong salamat. I'll see you in the next couple of hours on the other suggested answers. Thank you very much. I'll see you. Maraming pong salamat for finally waiting for me to be able to upload this particular thing. Marami pa pong may upload. Hindi po na-upload kasi po yung nagka-problema sa aking laptop arising from this COVID quarantine. Thank you very much. I love you all.